everyone, welcome back. Today I will be talking about another rule that CMS has unveiled related to surprise medical billing. On September 30th, the Biden-Harris administration, through the Departments of Health and Human Services, Labor, Treasury, and the Office of Personnel Management, issued an interim final rule with comment period to further implement the No Surprises Act, a consumer protection law that helps curb the practice of surprise medical billing. This rule details a process that will take patients out of the middle of payment disputes, provides a transparent process to settle out-of-network rates between providers and payers, and outlines requirements for healthcare cost estimates for uninsured or self-pay individuals. Other consumer protections in the rule include a payment dispute resolution process for uninsured or self-pay individuals. It also adds protections in the external review process so that individuals with job-based or individual health plans can dispute denied payment for certain claims. In early September, the departments and Office of Personnel Management issued a rule to help collect data on the air ambulance provider industry, in addition to a rule in July on consumer protections against surprise billing. Collectively, these rules take effect January 1st, 2022 and ban surprise billing for emergency services as well as certain non-emergency care provided by out-of-network providers at in-network facilities and limit high out-of-network cost sharing for emergency and non-emergency services for patients. What is a surprise medical bill? When a person with health insurance coverage gets care from an out-of-network provider, their health plan usually does not cover the entire out-of-network cost, leaving that person with higher costs than if they had been seen by an in-network provider. In many cases, the out-of-network provider can bill the person for the difference between the bill charge and the amount paid by their health plan unless prohibited by state law. This is known as balance billing. An unexpected balance bill is called a surprise bill. Who will benefit from this rule? Rules related to the No Surprises Act include important protections for the majority of consumers who do not receive health coverage through federal programs. The rules don't apply to people with coverage through programs like Medicare, Medicaid, Indian Health Services, Veteran Affairs Healthcare, or TRICARE, since each of these programs already has other protections against high medical bills. The rules also include key updates for people who are uninsured or self-pay for their care. Today's requirements related to surprise billing Part 2 rule details how providers, facilities, providers of air ambulance services, and plans and issuers can negotiate payment for out-of-network bills and can access the federal arbitration process when these organizations can't agree on payment arrangements, taking consumers out of the middle. The rule also addresses additional protections for uninsured or self-pay consumers who are seeking care and steps they can take if a medical bill is much higher than expected. Overall, these surprise billing protections apply to you if you get your coverage through your employer, a multi-employer plan, or through the federal marketplace and state-based marketplaces, or if you purchase coverage directly through a health insurance plan. If you are uninsured or self-pay for care, this rule includes protections to ensure you know how much your healthcare will cost before you get it and have a way to challenge a bill if it is much larger than expected. How does this rule help? This rule helps to limit costs you may have to cover when you get a surprise bill. In the event of a surprise bill, how much you have to pay is capped. This capped rate is determined by referring to a state payment agreement, state law, or the qualifying payment amount. The qualifying payment amount is generally the average in-network rate for the same or similar items or services for the health plan. The rule also outlines a process for resolving payment disputes between your out-of-network provider or facility and your health plan for how much the out-of-network provider or facility will be paid for the services you got when surprise billing protections apply. This process brings in a third party known as a certified independent dispute resolution entity that will work with the health plan and provider or facility to decide the payment amount. Good faith estimates for uninsured or self-pay individuals. The rule also protects uninsured or self-pay individuals from unexpected medical bills. Starting January 1st, 2022, a provider or facility has to give an uninsured or self-pay individual a good faith estimate of expected charges after an item or service is scheduled or upon request. For example, if you were getting surgery, the estimate might include the cost of the surgery, any labs or tests, and the anesthesia that might be used during the operation. If an item service is something that isn't scheduled separately from the surgery itself, it will generally be included in the good faith estimate. Other items/services related to the surgery that might be scheduled separately, like pre-surgery appointments or physical therapy in the weeks after the surgery, won't be included in the good faith estimate. To make this good faith estimate as useful for uninsured or self-pay individuals as possible, providers must provide a good faith estimate to an uninsured or self-pay individual within 1 business day after scheduling. This timeline applies when your primary item or service is scheduled at least 3 business days before the day you would receive it, or no later than 3 business days after scheduling. This timeline applies when your primary item or service is scheduled at least 10 business days before you would receive it, depending on scheduling, or within 3 business days after an uninsured or self-pay consumer requests a good faith estimate. The provider must include in the good faith estimate an itemized list of each item or service grouped by each provider or facility offering care. Each item or service has to have specific details and the expected charge. The provider must provide a paper or electronic copy of the good faith estimate, even if the provider also provides the good faith estimate information to you over the phone or verbally in person. The provider must provide the good faith estimate using clear and understandable language. This rule lays out a new dispute resolution process if you are an uninsured or self-pay individual and get a bill for an item/service that is substantially greater than the expected charges in your good faith estimate. Beginning January 1st, 2022, under this process, you can begin dispute resolution between you and the provider when your actual bill charges for a particular provider/facility are at least $400 more than the good faith estimate you were given. You have 120 calendar days from the day you get the bill to begin the process. You can request that a third-party dispute resolution organization review the good faith estimate, your bill, and information submitted by you and your provider/facility. The third-party dispute resolution organization will use this information to determine if the additional charges you were billed are allowed or if the provider can charge you only what was on your good faith estimate or some other amount lower than the bill. To offset some of the cost of operating the dispute resolution process while keeping it accessible, HHS will charge consumers an administrative fee of $25 in 2022. However, if the resolution ends in the consumer's favor, this fee will be credited back on their bill by the provider/facility. External reviews of denied claims for insured consumers. This rule expands the scope of the external review process, which is what individuals with group or individual health coverage can use to appeal a payment for a healthcare item/service that was denied by their health plan due to an item/service not being covered, restrictions on coverage, or the item/service not being considered medically necessary by the health plan. This rule specifically says that coverage decisions that involve whether a health plan is complying with the surprise billing and cost sharing protections under the No Surprises Act protections are eligible for external review. For example, if your plan/issuer covers emergency care under the No Surprises Act and you get care at an emergency room, but your health plan denies payment because it does not believe the items/services you received were emergency services, you could appeal this decision using the external review process, which will help determine whether your health plan needs to cover the care you got. In addition, grandfathered plans that are not otherwise subject to external review requirements will be subject to external review requirements for coverage decisions that involve whether a plan or issuer is complying with the surprise billing and cost sharing protections under the No Surprises Act. Consumer protections in the rule will take effect beginning on January 1st, 2022. Comments on requirements related to surprise billing Part 2 are due by 5 p.m. Eastern Time 60 days from the rule's publication in the Federal Register. You can submit your comments through the website which I have pasted on this slide. You can also find this website in the description box below. This is it for today's presentation. Thank you for joining me today. Hope you found this information useful. If you enjoyed this video, please consider subscribing to my channel. Take care. Bye now.